And we're back. And we're going to start out by talking about Second Amendment and then move on to the Fourth and Fifth Amendments. All right. So, text of the Second Amendment reads: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And this is obviously a controversial one because what does it mean? Well, does it mean you can possess a rocket launcher? Can you possess nuclear weapons? Possess a predator drone? Answer to these generally is no, because as with the First Amendment and all the other rights that we have, civil liberties we have, there are some restrictions here. Now, the Supreme Court has generally not weighed in on the Second Amendment as often as you might necessarily think. Most recent, or not most recently, but in 2008, though, they did rule for the first time that you do have the Second Amendment does protect an individual's right to possess a gun for self-defense within their own home. And this is an area where I suspect that probably the Supreme Court going forward is going to expand their interpretation to include more protections for gun ownership and carrying guns and things like that. But I don't know that. We'll have to wait and see. All right. So let's talk about criminal procedures here, investigations. Fourth Amendment establishes that no unreasonable searches and seizures in order to search someone's property. Generally, the police will need a warrant in order to do it. Police can only obtain a warrant, though, by going before a judge and demonstrating probable cause of some wrongdoing, some crime being committed. The Fourth Amendment, though, is a little vague. It does specify that warrants must be backed up by probable cause. Does this mean that police always need a warrant in order to come onto your property or kick down your door? The answer is not necessarily. No, the answer is no, they don't always need that. A warrant is not needed, for example, if there are illegal goods in plain view. So if a cop is driving down the street and sees a meth lab in your yard from the street, warrant's not needed at that point. If police observe a crime, a warrant is not needed to act at that point. If it is something that's time sensitive, say a cop is walking down the road and hears screams coming from a house, at that point they are allowed to kick down the door and find out what's going on, because the scream would be probable cause. And if they take the time to go before a judge and get a warrant, somebody might be dead at that point. So they don't 100% of the time need a warrant, but there are only very specific cases where they would not need one. Now, warrants apply only where there is a reasonable expectation of privacy. There is no reasonable expectation of privacy, say, in discarded garbage. So the police can go through your garbage. Your Fourth Amendment rights would not protect you at someone else's house or in a hotel room once you've checked out, an international border, or a public place. Dorm rooms generally are covered under the Fourth Amendment, but many private schools will require you to sign a waiver waiving this. You can waive your Fourth Amendment rights. Is it generally a good idea to do so? Probably not. Courts have found, though, that the level of protection you can expect under the Fourth Amendment, prohibition against unreasonable searches and seizures, is proportionate to areas where you would have the highest expectation of privacy. So you have the highest expectation of privacy and thus the strongest Fourth Amendment protections within your own home. In your place of business, you still have some protections there, but less. In your car, you still have some, but even less still. Again, there is no protection in any of these places for things that are in a plain view. If your business is subject to OSHA restrictions or to health department inspections, there is no warrant required to search them as well. Exclusionary rule was made binding in 1914 by the Supreme Court. What this states is that if evidence is found in violation of the Fourth Amendment, generally it is not admissible in court. Search of homes almost always requires a warrant. Again, maybe the only exceptions being being screams or something from a home. Businesses usually do, though, again, if it's subject to OSHA or something like that, not necessarily. Should say here too that man, just lost my train of thought there. So generally a warrant is required to basically search someone's private property. The standard to get a warrant is highest for a private home, lower for a place of business, lowest still for a car, though some protection does still exist there. If you're out in public, not really much protection there, really. All right, interrogations. Fifth Amendment says you have the right against self-incrimination, which means you cannot be forced to testify against yourself, which means if you are arrested, you have the right to remain silent. The Miranda versus Arizona decision of 1966 is famous here because it establishes a person's Miranda rights. It's actually a little misleading to say it establishes these rights because these rights always existed. They are in the Bill of Rights. But nothing in the Constitution says that a suspect has to be informed of their rights. So you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be provided for you. So you have the right against self-incrimination and the right to an attorney. These are protected by the Bill of Rights. They are in the Fifth Amendment. But it doesn't say that a suspect has to be informed that they have these rights. So if a suspect is unaware that they have these rights, are law enforcement likely to want to inform them of this? Probably not. And historically, they didn't before the Miranda decision. With the Miranda decision, now suspects have to be informed that they have these rights. And the story behind the Miranda decision is there was a guy named Ernesto Miranda in Arizona who was not a good guy. He's a civil liberties hero, but like a lot of civil liberties heroes, he was not actually a hero. He was, by all accounts, a terrible person, rapist, abuser of women. And he was arrested, and he was unaware that he had the right to remain silent and the right to a lawyer. And so the police were in no mood to inform him of this. And I think they probably also engaged in interrogation tactics, which could be considered torture. Ultimately, though, he was convicted, and he argued when he found out he had the right to a lawyer and the right to remain silent, he argued that his conviction should be thrown out because he had been denied his rights. And the ACLU took up his case, and the case made its way to the Supreme Court, and the Supreme Court agreed with him, ruled in his favor, so they vacated his conviction. The state of Arizona tried him again, though. They can do that. It's not double jeopardy since he was not acquitted, and ultimately convicted him again, and he went back to prison. He eventually got out. I believe he ended up he did not get his life in order, did not change, apparently. He ended up dying in a bar fight, and the person who killed him in the bar fight, if arrested, would be read their Miranda rights. So, fun fact. But yeah, so is it a good, you have obviously the opportunity, the chance to waive your Miranda rights if you're arrested. Should you do it? I'm not a lawyer, so I'm not going to give you legal advice, but I would probably not do it. All right, trial procedure. We have this right to an indictment by a grand jury. Again, this is only at the federal level. You do have the right to counsel an impartial jury of your peers and right against self-incrimination. So once upon a time, the right to counsel meant you only had the right to an attorney if you can afford one. But since 1963, with the Gideon versus Wainwright decision, all defendants who could spend even a day in jail are entitled to a lawyer. If they can't afford one, they will get a public defender, which will be appointed to them. Verdict and punishment. If once you're acquitted of a crime, you can never be tried again for the same offense. This is double jeopardy. Even if you confess later, or if irrefutable proof later is found that you committed the crime, you cannot be tried with that crime again. So there is one exception to this. The Supreme Court allows a defendant to be tried for the same offense if the crime is both a state and a federal crime. Most crimes are either state offenses or federal offenses. There are very few which are both. However, if you commit a crime that is both, you can be tried at the federal level after you've been acquitted at the state level. This usually happens when it does happen with civil rights cases. The federal government, as we'll talk about when we talk about civil rights, has passed civil rights legislation. This was largely, or partly, I should say, in response to the fact that it was very difficult in certain states like Alabama, Mississippi, etc., to convict white people who committed crimes against black people in the 1960s and prior. So even though it's clear as day that the person is guilty of this, juries would refuse to convict them. And so the federal government passed civil rights legislation, which allowed them to prosecute people like this at the federal level for civil rights violations. These laws are still on the books, and so they can still be prosecuted. It's not very common this happens, but it can happen, and sometimes it does happen. One case of this, it's before your all's time, but I remember, was the Rodney King incident in Los Angeles. There were 4 white police officers who were accused, or there was actually a tape recording of them beating a guy named Rodney King. A jury in Los Angeles acquitted them for it. Later on, the federal government, though, brought charges against them for civil rights violations, and 2 of the officers were convicted and 2 were acquitted. All right, so in sentencing, a judge determines the sentence if convicted. This is at the federal level only, except in death penalty cases. It takes a jury to sentence someone to death at the federal level. A judge alone cannot do it. And a judge also, I believe, has the authority to overrule a jury if they sentence someone to death. Generally, they don't, but they do. In some cases, they might. All right, so we are going to stop right there for right now. We will come back and finish up civil liberties next. We'll talk about right to privacy and some other controversial stuff. So I will talk to you soon. Goodbye.